Well, welcome everybody. This is Christian Bolduc, principal at Smart & Biggar. Thank you for joining us for our webinar today on Bill 96. Together with me today, we have Francesca and Stéphanie Girard, two lawyers who are very experienced with the Charter of the French language. But before we begin, a couple of housekeeping notes. First of all, you have a Q&A box at the bottom of your screen if you have questions. We're going to take questions along the way. So please do not wait until the end of the webinar to actually ask your question in the Q&A box. At the end, there will also be a survey that will pop up. So please fill out the survey and let us know what you thought of today. And I think it also asks questions about what you would like to hear from us in terms of topics. The webinar will also be recorded, so you will have access to the recording and to the PowerPoint presentation. So I introduce the speakers, and now I will pass on the floor after this slide that talks about us, Smart & Biggar. So we're across the country, 130 years, 180 lawyers with the last few acquisitions. There you go, Stéphanie, it's yours.
Thank you, Christian. Good afternoon, everyone. So on the agenda today, we will start with an overview of the legal framework for French language requirements in the province of Quebec. Then we will discuss the general rules and some of the key exceptions for the language of inscriptions on products in the province of Quebec. We have prepared a few case studies to help you understand how the general rules and some of the key exceptions may apply in practice. So we will go over these case studies with you. And we will finish the presentation with an overview of the complaint and investigation process. There should be approximately 10 minutes left at the end of the presentation to answer your questions. So next slide. And next slide, so the legal framework. So the main law governing French language requirements in Quebec is the Charter of the French language, so the French Charter. The French Charter was adopted in 1977 to protect the French language in all spheres of public life in Quebec, which includes the sphere of administration, instruction, labor relations, and commerce and business. So the French Charter gives the status of official language to the French language, making its use mandatory in Quebec in all spheres of public life. Now, for the territorial application of the French Charter, the French Charter applies to businesses with an establishment in Quebec, which includes a PO box, but it also applies to businesses that are not established in Quebec if they offer services or they sell their products to consumers in Quebec. The focus of today's presentation will be on commerce and business, more precisely on the language of inscriptions of products sold or available for sale in the province of Quebec. But you should bear in mind that the sphere of commerce and business also includes commercial publications such as websites and social media pages, and public signs and commercial advertising. But we only have 1 hour for the presentation, so we won't have time to discuss the general rules and some of the key exceptions for commercial publications, public signs, and commercial advertising. But if you are interested in these topics, please do not hesitate to reach out to Christian, Francesca, or to myself. So I already mentioned that the main law governing French language requirements in Quebec is the French Charter, but you should always keep in mind three other pieces of legislation, which are the regulation respecting the language of commerce and business, Bill 96, and the regulation to amend mainly the regulation respecting the language of commerce and business. So the regulation respecting the language of commerce and business essentially contains exceptions to the general rules set out under the French Charter. As for Bill 96, it was adopted on June 1st, 2022, to better protect the French language in the province of Quebec. I'm pretty sure most of you are already aware that Bill 96 had a major impact on the language of commerce and business, more precisely on the trademark exception for products, which we will discuss in greater detail later in the presentation. As for the regulation to amend mainly the regulation respecting the language of commerce and business, as its title suggests, it amends the regulation respecting the language of commerce and business, essentially to clarify the provisions that were introduced in the French Charter by Bill 96, and we will refer to that regulation in the presentation as the new regulation. So I will now turn to Francesca for the general rules for products.
Thank you, Stéphanie, and thanks, Christian, for the introduction. So the general rule for inscriptions on product under the French Charter, which also includes, by the way, the product container, its label or packaging, as well as any documentation that is supplied with it, is that all inscriptions needs to be in French or in French and another language, but provided that the other language is not given a greater prominence than French or available on more favorable terms. So Bill 96 did not materially impact this general rule under the French Charter. However, it did add the language available on terms as favorable, which was recently clarified in the guidelines that were published by the OQLF. So essentially what it means is that a consumer in Quebec should not have to make any extra effort to access the French information. So we can think, for example, of a user manual that would be included in a product packaging, and that would be available in English only. But that would redirect the consumer, for example, with a QR code to the French version available online only. So obviously, this type of documentation would most likely not comply with the available on terms as favorable requirement. So a couple of current key exceptions. There are many under the French Charter and especially under its regulation, as just mentioned by Stéphanie. So inscriptions that are, for example, inscriptions that are engraved, inlaid, or embossed in the product itself. They could be also baked, rifted, or welded in the product. So they would not require French translation, but provided that they do not concern safety and that the product is manufactured outside of Quebec. Another exception is for name of origin, also a name for an exotic product or a foreign specialty. They would not require French translation. For example, the word valley on the wine bottle on the slide would most likely not need French translating, since Okanagan Valley is a protected geographical indication in Canada. There is also an exception for software. So the content of a software does not need to be translated in French. However, provided that there is no equivalent in French of the software that is available anywhere. This is an exception under the French Charter that is referred to as the international usage exception. And Christian, I think you have received, well, I know you have received some input recently directly from the OQLF about this exception. So maybe you could just talk about that exception a little bit.
Thank you, Francesca. Yes, indeed. So in a recent meeting with the folks from the OQLF, that was one of the questions that we asked. What about certification marks that appear on products, making them understand that certification marks do not belong typically to the manufacturer of the products, that they are owned by third parties, that they are subject to licenses, and that the licensees, those that apply those certification marks on their products, cannot modify them in any way whatsoever, and certainly not translate them. And so they said, that's not a problem. It would essentially be considered as something that would fall into this international usage exception. Of course, to the extent that the international or the certification mark is one that is used on a large scale, i.e. international. So that's what I was offered in terms of response. Makes sense. Of course, this international usage exception would probably fit in other type of situations. So it's something that people should bear in mind. It's at Article 92 or 92 of the
Yeah.
Charter of the French language, if ever you're looking for it.
Thank you, Christian.
And somebody's asking me if the slides are going to be shared after the presentation, and the answer is yes.
Thank you. So our last exception is the recognized trademark exception, which I think many of you are familiar with. So a recognized trademark does not need to be translated into French, but provided that no French version of the trademark has been registered in Canada. So Christian, let's go to the next slide. Thank you. So what is a recognized trademark? So it's a trademark that is either registered or unregistered, i.e. a common law mark. So common law marks are trademarks that have been used, promoted, and advertised in Canada to such an extent that they have become known. So currently, both registered and common law trademarks will trigger the recognized exception. And this is not going to change as June 1st, 2025, since the new regulation recently reintroduced the common law exception for inscriptions on product. However, there is a difference in relying on a registered trademark versus relying on common law rights to trigger the exception in the event of a complaint being filed before the OQLF. So the benefit of having a registration, if a complaint is filed and if the OQLF requires that you translate an inscription that is a trademark registration. So what you would do is you would show the OQLF your certificate of registration, and that mostly would put the matter to an end. Of course, this is not true with common law trademarks. And what is important to keep in mind is that the people at the OQLF, they're not trademark lawyers, so they're not equipped to assess common law rights. And it's not before the OQLF that you would have to make such an argument. So essentially, what you would have to do is to wait for the OQLF to issue an order. And we will go through the complaint process later. But for now, the important thing to understand is that you would have to wait for the OQLF to issue its order. And you would then have to appeal that order before the Tribunal Administratif du Québec, the TAC, and you would have to prove your common law rights before the TAC, which we may think is not highly sophisticated in trademark law. So of course, all of this, I'm just gonna finish rapidly. 1 second. So of course, this would prove most likely to be more time consuming and costly. And this is why we usually recommend to our client that they do not rely on common law rights to trigger the exception, but to rather translate into French when securing a registration in Canada is not available.
So the recognized trademark exception, what it is, pursuant to the current trademark exception, a non-French recognized trademark on a product, including on its label, packaging, a container, or any object or documentation supplied with the product, does not need to be translated into French, provided that the French version of the recognized trademark has not been registered in Canada. So the recognized trademark exception will stay the same until June 1st, 2025. As of June 1st, 2025, a non-French recognized trademark on a product, including its label, container, packaging, and any documentation or objects supplied with the product, will not need to be translated into French, provided that the French version of the recognized trademark does not appear on the Canadian Trademark Register, with the additional requirement that any non-French generic or descriptive language in the recognized trademark will need to be translated into French and appear on the product or on a medium permanently attached to the product. For now, we do not know what is meant by the expression on a medium permanently attached to the product, but what we know is that if a French translation of a generic or descriptive term appears on the product itself, it will have to comply with the equal prominence requirement or the as per rule terms requirement as explained by Francesca earlier in the presentation. So in sum, the most significant change between the recognized trademark as it is today compared as what it will be on June 1st, 2025, is the requirement to translate non-French generic term or descriptive term in the recognized trademark. So what is a generic term and what is a descriptive term? We can go on next slide for the answer. So the new regulation and Bill 96 are unclear on what is considered a generic term or a descriptive term. So there's a definition in the new regulation, but it does not really provide clarity. So a generic term is a word that describes the nature of a product, excluding the name of the enterprise and the name of the product as sold, whereas a descriptive term is a word that describes the characteristics of a product, excluding the name of the enterprise and the name of the product as sold. So the new regulation and the recent guidelines published by the OQLF are unclear as to the meaning of name of the enterprise and name of the product as sold. However, based on our interpretation, we think that name of the enterprise would mean the brand name that matches the trade name of a business, and name of the product as sold would mean a product brand name. Again, Bill 96, the new regulation, and the OQLF's guidelines are unclear as to the impact that the new trademark exception will have on secondary, on tertiary brands and on brand names for ingredients, perfumes, scents, flavors, and technologies. The case studies that we have prepared for you should give an idea of how we think that the new trademark exception will apply to some of these types of brands. So we will discuss this case study in a few slides.
Thank you, Stephanie. I have a question here about the trademark exception. So somebody's asking, the trademark exception currently includes common law trademarks. The understanding was that Bill 96 removed common law trademarks from the exception, and yet now we're saying that the common law trademark is still included in the trademark exception. So maybe I can take that one myself and explain that that is correct. Bill 96 removed common law trademarks from the trademark exception. The language is pretty clear. And the regulation reintroduces the common law trademark as part of the trademark exception. Now, that is an interesting way of fixing some drafting issue, perhaps with the statute as amended by Bill 96, but it is nevertheless what we have now. So essentially, as Francesca and Stéphanie have indicated, so far as the common law exception is concerned, it will carry forward after June 1st, 2025, with the additional requirements that Stéphanie has mentioned and that we will try to explain further with the examples.
Thank you, Christian. So the new trademark exception will come into force on June 1st, 2025, but businesses will have until June 1st, 2027 to translate non-French generic or descriptive terms included in their recognized trademarks. The 2-year grace period will be available for products manufactured before June 1st, 2025. And it is important to note that the grace period is only available to comply with this specific requirement. It is not available to comply with the general rules or other exceptions for products under the French Charter or the regulation respecting the language of commerce and business. So it is only available to allow more time for businesses to translate their non-French generic or descriptive terms in their recognized trademarks. So Francesca, I will turn to you for the case studies.
Yes, thank you, Stéphanie. So we have a couple of case studies that will allow us to illustrate the application of Section 51.1, which pertains to registered trademark as of June 1st, 2025. So in our fictional scenario, we have a business called Eco Body Care, which commercializes hand soaps under the trademark Best Soap. The Best Soap branded product are offered in a wide range of fragrances, which names that are sometimes descriptive, sometimes suggestive, and that are other times registered as trademark. And we will have an example as well of a Best Soap branded product, which include a branded ingredient sourced from a third party. Thanks, Christian. So this first example relates to the positioning of the French translations of descriptive and generic terms after June 1st, 2025. Excuse me. So, and these examples, they were provided by the OQLF, so it's important to note it. On the image on the left, we have a hand soap product bearing a label with English inscriptions only that is registered as a trademark. So it is the entire label that is a trademark registration in Canada. So the OQLF confirmed that this product would no longer comply with the French Charter as of June 1st, 2025, since all the inscriptions appearing on the label, except for Best Soap, which would be understand as the brand name of the product. But all the other inscriptions in English would be considered either descriptive or generic and would have to be translated into French. However, we know that the OQLF also confirmed that the same product is currently compliant with the French Charter and would be compliant until June 1st, 2025. And this is because the label is registered as a trademark in Canada, such that the product can benefit from the recognized trademark exception. On the image on the right, we see, just the image on the right, we see the same product, and we see that the French translations of the descriptive and generic terms appear underneath the registered trademark. So the example confirms that a registered trademark does not have to be modified for the product to comply with the French Charter as of June 1st, 2025, and that the French translations, they can appear elsewhere on the product. And this is really important from a trademark's perspective, since, of course, altering a registered trademark is not a good practice, as it could affect the validity and the distinctiveness process of the registration. For example, in the context of cancellation proceedings for non-use, where a registration for a trademark that is not used as it is registered could be vulnerable to cancellation. And we'll go to the next slide. Thank you, Christian. So this is another example that was provided also by the OQLF. And this example confirms that the French translations of descriptive and generic terms can appear on a different side of the product than the one on which the registered trademark appears. Of course, while the equal prominence and available on terms as favorable requirements are met. We can go to the next example, and Stéphanie, I will let you explain it.
Thank you, Francesca. So in this example, the entire label comprising of best soap, spring breeze, moisturizing hand soap, hypoallergenic, and kills bacteria is registered in Canada, and the French version of the label has not been registered in Canada. So as Francesca mentioned, this label is currently compliant with the current trademark exception, and it will remain compliant until June 1st, 2025. As of June 1st, 2025, some of the language included in the registered label may need to be translated into French pursuant to the new trademark exception. So, for example, clearly descriptive language such as moisturizing hand soap, hypoallergenic, and kills bacteria will need to be translated into French, but it is not clear in this specific case, where the entire label is registered as a trademark, what will happen with Spring Breeze? So how will the OQLF perceive inscriptions that are suggestive rather than being descriptive? We think that the OQLF will perceive Spring Breeze or other language that is suggestive as being descriptive and as requiring a French translation. So in other words, we think that the concept of the OQLF for generic and descriptive terms will be looser than the concept that is generally accepted under Canadian trademark law. So we think that maybe Spring Breeze will have to be translated into French. However, for best soap, which is a combination of a descriptive term and a generic term, we think that the OQLF would perceive best soap as being the name of the product as sold, and best soap would not need to be translated into French. In this example, we wanted to highlight the importance of using your mark as registered. So you have to remember that agents at the OQLF are not trademark trained. So we think that a business that wants to rely on its registration to trigger the trademark exception would be in a better position if it is able to provide the OQLF with a certificate of registration in which the registered mark matches the mark as it appears on the product. So essentially, the OQLF may not approach the situation as a trademark agent would. So a trademark agent would look at the registered mark and the mark as used and would assess whether the registration would survive summary cancellation proceedings based on non-use. But we think that the OQLF will look at the registered mark and the mark as used and may consider that small differences between the mark as registered and the mark as used are sufficient to block the application of the trademark exception.
Thank you, Stéphanie. So I'll take it from here. Here we have another example where Best Soap and Spring Breeze are both registered as trademark in Canada. So again, we assume in our example that Best Soap would be perceived as the product brand name, and thus that would not be required to be translated into French. And Spring Breeze here would most likely be perceived as the fragrance brand name. And as mentioned by Stéphanie, it is most likely that the OQLF would consider Spring Breeze to be descriptive. However, from a trademark perspective, Spring Breeze in association with hand soap is at the most suggestive, and in our view, it would be sufficiently distinctive to be registered as a trademark in Canada. So this is a potential solution that businesses may want to consider, and that is to register their suggestive secondary trademark, and even to register suggestive component of registered trademark as standalone word mark. For example, in our first example where Best Soap and Spring Breeze are registered as an entire label. And of course, there is no certainty for the time being. And the guideline that was recently published by the OQLF also specifically lists perfume names and ingredient names as potentially being descriptive. But the rationale, in our view here, is that owning a trademark registration for a trademark such as Spring Breeze would be a very strong argument to put before the OQLF that such a trademark is not descriptive, since it was considered registrable by the Canadian Trademarks Office. In other terms, it would have been considered not descriptive nor generic. In this other example, this is an example of a brand name that matches the trade name. So here we consider that Eco Body Care, which would be perceived as the name of the enterprise, and Best Soap, which would be perceived as the product brand name, and which are both registered as word marks. So neither Eco Body Care nor Best Soap should be required to be translated into French as of June 1st, 2025. Here we have a third-party branded ingredient, so the Magic Pearls body oil that is incorporated in our product. So here what happens with Magic Pearls, so it would mostly be perceived as the brand name of an ingredient. But we don't know we have no certainty of how the OQLF would react to such a trademark. So could the OQLF require that a trademark that is not owned by our company, Eco Body Care, be translated into French? It's a big question mark here, but we believe again that the fact that Magic Pearls is a registration in Canada would be a strong argument to put before the OQLF for the reason already mentioned. And in addition here, Eco Body Care could also be precluded from under a trademark license from using a French version of the trademark Magic Pearls. Which would add another layer of complexity to the case.
Thank you. So we have numerous questions here. I don't know if it's a good time to go through some of them, or if we move to maybe we talk about them before the complaint and investigation process, at least some of them.
Yeah.
We still have
Okay.
time. So one of those questions has to do with the exception to the trademark exception, i.e. if a French version of the trademark has been registered. So somebody noticed the difference in the language between how the regulation currently reads versus how sections 51.1 and 58.1 read. And so would one of you care to comment about this difference in language?
Yes, I can comment on this one. So yes, indeed, there is a difference in the language between the current exception, which says provided no French version has been registered, and the exception as it will in section 51.1, which says provided no French version appear in the register. So of course, the language appear in the register. Technically, it could cover, in addition to registered trademarks, it could cover pending application and even abandoned registration or withdrawn application. However, we have received recently confirmation from the OQLF that they would interpret the language appear in the register as meaning registered trademarks. So of course, this could open the door to businesses so that they can cancel registration potentially or withdraw pending application to be able to rely on the exception. Of course, there is a difference between two provisions under the French Charter, the current one and one which will come into force in 2025. So it's not excluded that this could be interpreted differently by a court.
Thank you, Francesca. So somebody noticed that in the examples that the OQLF has provided, where the French translation appears underneath the trademark or on another panel of a product packaging, that those approaches are considered compliant, i.e. that it is satisfying the requirement to be available on terms as favorable, even if it's not at the top, even if it's not on the same panel as the trademark that is registered in a language other than French. So either of you care to comment about that?
Well, this is correct. I think it's in keeping with the equal prominence requirement. It can be, there's no requirement that French appears first or second. The only requirement is that it be in equal prominence and that a consumer does not have to make any extra steps to access it.
All right. So somebody is asking about international usage, whether that would also cover situations where, let's say, a product has won some award of some international competition or some competition somewhere. Any one of you would care to comment on that? Would that need to be translated, that international award logo, or could it be left at as is and an argument could be made with the OQLF in such a situation?
I think then that an argument could be made if the logo is internationally known, but I think it will be assessed on a case-by-case basis, especially since there's no clear guidance from the OQLF on that specific exception. So I think businesses should be careful when relying on this exception. But if the logo is internationally known, maybe it would worth giving it a try.
Thank you. I guess we're gonna pick up on the complaint and investigation process. So I guess that would be me, or is it someone else?
It will be me, Christian.
All right.
So the Office québécois dans langue française, the OQLF, is the administrative body in Quebec in charge for enforcing the French Charter and its regulations. The OQLF has the power to issue orders and to seek injunctions, but it does not have the power to grant fines. Only the Court of Quebec has that power. So the OQLF is generally reasonable with businesses that are willing to comply but need more time to do so. So that is probably why the vast majority of the complaints are resolved amicably with the OQLF. So for instance, in 2022-2023, approximately 85% of the complaints were resolved with the OQLF. So we can say that the role of the OQLF is to educate rather than to punish, and we have no reason to believe that the role of the OQLF will change in 2025 when the new trademark exception will come into force. So I will let you, Christian, explain the complaint and investigation process.
Thank you, Stephanie. So the way it works in practice is that although the Office québécois de la langue française that we referred to until now as the OQLF has the power to initiate a process on its own, typically they do so when someone files a complaint. Who can the someone be? It can be anybody that lives in Quebec. It could be a competitor. It could be a disgruntled employee. Anybody in Quebec can file a complaint. The complaint is received, and typically it's processed within about 30 days, at which time it lands on the desk of an inspector. Whether the inspector decides to action the complaint immediately or not will depend on the level of urgency that is perceived. If there is some safety concerns because some language is not in French and it may create a safety risk, security risk, then they will probably consider those more priority than those that are not so related. So the inspector, let's say the inspector looks at the complaint, considers it to be, well-founded. Then what happens next is that the OQLF will send a letter to the business or businesses that are perceived to be in breach, asking the businesses to provide their comments within a certain timeline. Now, here, there's a number of things that can happen, obviously, but if we take a scenario where the business is of the view that the complaint is not justified, argues or puts and basically makes its position known to the OQLF, but the OQLF maintains its position that there is a breach, then what would happen normally is that the OQLF would issue an order. Now, this order, as has been explained before, can be appealed. And the appeal process is before an administrative tribunal, which is the TAC, as already mentioned. And then in front of the TAC, you can argue the case again. If you're not happy with the decision of the TAC, then you can go in revision to the Superior Court of Quebec. You can appeal to the Court of Appeal, and you could even request permission to appeal to the Supreme Court of Canada. So this whole process could actually end up taking a couple of years. Now, some businesses may take that as a strategy for avoiding to translate if translating would be more costly than going through all those steps, which, as you can imagine, can also be quite costly. Now, if the order becomes final, either because it has not been appealed or the appeal process has been gone through, ended, and the decision is final, then it becomes final. And if then the business is still not complying, then the OQLF has two options. Option number one is go to the Superior Court and convert the order into an injunction, which would basically, for example, mean that if there are still problematic products or signage out there, that they should be removed or modified within a certain timeline, and failure to do so would be contempt of court. The other option is to go to the Cour du Québec, which is where the OQLF would need to refer the case for penal proceedings. Now, if the case goes to the Cour du Québec for penal proceedings and the whole thing has been pending, let's say, for a few years, the penalties or the sanction are not calculated based on when the decision by the OQLF or the order by the OQLF was first issued. It starts being calculated from when the order became final after the whole appeal and revision process is over. So, as you know, the sanctions can be multiplied by days of breach. And so what was explained to me in practice is that the way it works is that even if a month, 2 months, 6 months, or a year has elapsed between the moment that the proceedings were started in the Cour du Québec and the moment that the hearing takes place, in practice, the file that will be built by the prosecution is gonna basically will notify or will note an infraction over a number of days, maybe a week, maybe 2 weeks, but certainly not for an entire year to build the file. So you're looking at a multiplication that would be not as dramatic as what can be potentially contemplated. So that's the process, and it's something that you need to know. Now, one more thing that I did not address that is very important is that the OQLF has a mandate of educating the public more than punishing, and businesses more than punishing them. So to the extent that a business, after receiving the complaint from the OQLF or the formal letter from the OQLF, shows a willingness to comply, but requires sometimes to phase out problematic products and introduce replacement products, our understanding and our experience is that the OQLF will show flexibility and will accept that it takes time to replace a problematic product on the market with some other product that is fully compliant. In other words, so long as a business negotiate and discuss in good faith with the OQLF and shows a willingness to address the situation that is brought to its attention, the result is likely that an order is not going to be issued in those type of circumstances. So the risks, well, as we mentioned, the risks are fines if the order is issued, is not complied with, and the OQLF decides to refer the case to the Cour du Québec for penal proceedings. The other aspect, as we've mentioned, is an injunction, which would force a business potentially to withdraw products from the market, recall products from the market, which, as you can imagine, is a very costly endeavor. There's also what some people refer to as the atomic bomb, which is the suspension or revocation of all permits granted by any government control entities in the province of Quebec, and that could cover permits to operate potentially. So that type of sanction is pretty dramatic and could ultimately almost block access to the Quebec market to some businesses. Of course, there's also the reputational risks that are associated to those type of proceedings when decisions are rendered by the tribunals and the media monitor these decisions and report them, and people become aware of them. So that's obviously something that is less than ideal. Now, in terms of other repercussions that were introduced by Bill 96, there's the right to live in the province of Quebec in French, the right to live, consume products and services in French. So irrespective of the entire process in front of the OQLF, Quebec citizens have access to another recourse that is independent, that could potentially give rise to class actions. I mean, this has been enforced in June 1st, 2022, and to our surprise, to this day, such class actions have not been initiated. It doesn't mean that consumers have not on their own initiated actions in front of the court that we would suspect would be in front of the small claim courts, but we're not aware of that because those proceedings are hard to track. So this is something that businesses need to be aware of. So irrespective of what's going on in front of the OQLF, consumers could launch these type of proceedings in front of a court. Now, before we go to the takeaways, quickly, some statistics. So the most up-to-date statistics that we've received about a month ago is that in the last year, 10,000 complaints were received by the OQLF. Many of them were unfounded. Of those that were founded, the vast majority basically fit in three main categories. The first one is the language of services. Imagine you walk into a restaurant in Montreal or elsewhere in Quebec and somebody addresses you in English. So that would be considered a breach to the right to consume services in French. That's category number one of complaints filed with the OQLF in the last year. Number two, signage on building, which is a big issue with Quebecers, especially in cities such as Montreal, where a lot of signage bear non-French trademarks. Number three, websites and social media, as was mentioned at the outset. This is another category. As far as products are concerned, it accounts for less than 6% of complaints filed with the OQLF in the last year. So we have about 8 minutes left. So before we move to the last question, I know there are a couple of key takeaways, so I'll turn the mic back to you.
Thank you.
Francesca.
Thank you, Christian. So yes, a couple of takeaways, what businesses can do. So first, do not apply to register French versions of your trademark. So that's the first thing to keep in mind. Second, you can revise your portfolio of Canadian registrations to determine if trademarks will require French translations as of June 1st, 2025. In doing so, you can look into French dictionaries. There are many words that are the same in English and in French and have the same meaning, such that they would not potentially require to be translated into French. Also identify combination trademarks that incorporate suggestive non-French words and consider applying to register these suggestive components, like in our many Spring Breeze examples. For components of trademarks that are descriptive, so most likely not registrable per se, but that have acquired distinctiveness on their own, you may consider filing individually and showing acquired distinctiveness to secure a registration, as this could be less costly than having to appeal an order from the OQLF. Third, of course, apply to register your common law marks when they are registrable, and also you can consider accelerating prosecution of your pending applications when it's possible. For example, by amending your application to select goods and services that are from the pre-approved lists in the goods and services manual in Canada. So currently the time for examination of applications using the pre-approved list is approximately 15 months. Fourth, ensure trademarks as used correspond to trademarks as registered, as mentioned by Stéphanie. And finally, evaluate your risks in the event of a complaint at the OQLF. So more specifically, evaluate the time that would be needed to phase out a product and to rebrand.
Thank you, Francesca. Stéphanie, question for you. What about pending applications? Do they trigger the exception?
No, they don't. Theoretically, they don't, because only registered or common law marks trigger the trademark exception. But you have to remember that the OQLF is generally reasonable. So if you have a pending application that will mature to registration, let's say in 4 months, there's probably a discussion to have with the OQLF, and maybe you could request a transition or an additional phase out period until your mark your pending application matures to registration. So I think the answer is no, but why not make the argument with the OQLF because they are willing to find solutions with non-compliant business. So I don't think that in practice, pending application necessarily block the application of the trademark exception, but it will be on a case-by-case basis.
What about trademark symbols? Do we need to translate those?
That's a good question. The general rule is that symbols are a combination of letters or with numbers, so they cannot be translated. However, the current position of the OQLF is that if a symbol exists, let's say in English and in French, use of the symbol in English would be acceptable. So I'm thinking of the TM symbol for trademark. There's an equivalent in French, which is MC, marque de commerce. The current position of the OQLF is that use of the TM symbol, so the symbol in English, is acceptable.
Thank you. Are we expecting further guidance from the Quebec government or the OQLF before the coming into force of Section 51.1?
We don't, at least not until the new regulation, the new trademark exception is discussed by courts in Quebec. Of course, we don't know if that will happen in the near future because the new trademark exception is not already in force. So we will have to, monitor the landscape. But for now, we don't think that the OQLF will issue new guidelines on the trademark exception for products, at least not in the near future.
Thank you. There's many more questions. We have just 3 minutes left. People are asking, okay, what do I do? Do I register marks combining different marks together as word marks? Do I register designs? What do I do? I guess it will depend on the circumstances of each case, and correct me if I'm wrong, but I guess there's no perfect solution, one size fits all in as far as the charter of the French language is concerned. Are you in agreement with that?
Yeah, totally. It's a case-by-case basis, and it's important also to assess each case to see how the language appear, how the mark is reproduced on product, for example. And of course, there is no one-fits-all solution, as you just said.
All right. We have more questions. So people are asking, what if I operate a website from the US and I sell my products online in the province of Quebec? Is my website subjected to the requirement of the Charter of the French language?
Again, I think it's on a case-by-case basis, but I think that yes, there is a risk that the website has to comply with the French Charter if a consumer in Quebec can purchase a product on the online platform, even if the company is based in the US. So there's a risk.
Somebody is asking, if a product has an exotic product has a certain name in a certain country, do we need to translate that name when the product is commercialized in the province of Quebec? So maybe you can give an example of what would be an exotic product.
Yeah, well, that's a good question. Actually, we don't have example, unless Christian, you have something in mind, but I know that in such a case, the OQLF would look if there is a French equivalent, and if there's not, it could open there could be room to argue that it's an exotic product. But the OQLF, if a complaint were to be filed, the OQLF would first look if there is an equivalent already available in French.
All right. Well, thank you very much, Stéphanie and Francesca, for the presentation today. We only have 10 seconds left, so I remind people to please fill in the questionnaire, send your questions. We are sorry we could not address all of them. There's about 30 or 40 of them, so we apologize. But stay tuned for more. If there is more guidance, there will be more from us. Have a nice afternoon. Bye-bye.
Thank you.
Bye-bye. Thank you,
Bye-bye.
everyone.